Hello, welcome to this video on voluntary manslaughter. This video will focus on diminished responsibility as a defence to murder. The focus on this video is going to be on when this defence can be used, the definition of the defence, the elements of the defence with accompanying cases to support and so on, and then of course the link between intoxication and diminished responsibility. So before we start, we're going to look at why you might be studying voluntary manslaughter. Now, voluntary manslaughter will likely be combined with a question on murder within the exam because this is its nature. It's a defence only to murder. So this means murder must be proven, as in all the actus reus and mens rea elements of murder before raising the defence. Now, to look in the question, and for diminished responsibility specifically, you can usually identify the partial defence which may be used through the language used in an exam scenario. So, for example, the defendant will be suffering from delusions or depression, or will have an addiction of some description. So we need to be careful with the language, looking into why it will not normally tell you what defence you need to be using, and so therefore you need to look into the language. The first question we need to ask ourselves with respect to diminished responsibility then is, when can it be used? Now, this is a partial defence to murder, which means it reduces the conviction from murder to manslaughter, which means we have a discretionary life sentence instead of a mandatory life sentence. Now, potentially it's used where there's something which impairs the defendant's mental responsibility for the murder. So don't go down the path of saying there is no mens rea because of this. We apply murder first and then raise a defence because of something which makes the defendant do what they did, and that's what this defence does. Now, normally it's raised by a defendant, but can be also given as an alternative verdict by a jury. Now, the CPS accept 3/4 of all pleas where there's medical evidence, which is quite clear. But of those that remain, the other quarter, only a quarter of these defences are successful at trial. So what we'll see in the case law are a lot of appeals, for example. So with this defence, the actus reus and mens rea are either admitted or proven if a defendant raises a defence. Now, what they do is use this to indicate that the defendant is truly not at fault. We discussed in the previous slide this idea of responsibility being diminished because of a condition which makes them do the killing in this case. Now, the burden of proof is on the defendant to prove on the balance of probabilities, which means more likely than not that the condition made them do what they did at the time of the killing. And as mentioned again, it reduced the conviction from murder to manslaughter, which means a maximum life sentence to discretionary life sentence. Now, of course, this gives scope as well for treatment to be given alongside. A quick note on the origin or definition of this defence then is that Section 2 of the Homicide Act first created this defence, but it was amended later on by Section 52 of the Coroners and Justice Act 2009. Now, we'll note this act as well because it of course also created the defence of loss of control as opposed to provocation, so this is the other type of voluntary manslaughter we look at. But I'm not going to read through this, you can pause this and read through. We're going to look at a simplified version of this definition instead. So Section 2 just gives that definition, you can just read through, but we will give a definition on the next slide. So a broken down version of this definition is this then. So Section 52, subsection 1 of the Coroners and Justice Act 2009 tells us that a person who kills or is party to a killing of another is not to be convicted of murder if the defendant was suffering from an abnormality of mental functioning, which also arose from a recognised medical condition, and this abnormality of mental functioning substantially impaired the defendant's ability to understand the nature of his conduct, to form a rational judgment, or to exercise self-control. And this abnormality of mental functioning provides an explanation for the defendant's acts and omissions in doing or being party to the killing. So this just means there's a causal link between the medical condition and the killing. Don't get confused here though with this condition being the cause of death, as already dealt with in murder. So we're going to be clear here, and we're going to deal with these in 4 different areas. So we've got the 4 elements clearly linked here, and we're going to come back to this in this tile format. So we're going to deal with this first element. The defendant must have suffered from an abnormality of mental functioning, and then we'll look about what means by a recognised medical condition, the substantial impairment of a defendant's responsibility, and then a causal link to providing of an explanation for the actual omissions. So we will, of course, deal with the first one first. The defendant suffered from an abnormality of mental functioning. So, as we can see, this element is the vital element. Everything must stem from this for the defence. So the defendant must have suffered from an abnormality of mental functioning. Now, what it means is an abnormality of the mind. Now, this is held to be something which is so different from ordinary human beings that a reasonable man would find it abnormal. This was the old test from Byrne. It's developed now into abnormality of mental functioning, which is ever so slightly different. Now, abnormality of mental functioning means it can be a physical disease also, which can affect mental functioning rather than the mind being disordered or abnormal. So it is for the defence to prove the defendant was suffering from an abnormality of mental functioning, and this has always got to be supported by medical evidence. We mentioned this case Byrne just before. Now in this case, the defendant suffered from perverted sexual desires, which created irresistible impulses. And of course, diminished responsibility covers all activities of the mind, which includes, as we say, physical diseases or impulses which affect the mind. Now, he was originally convicted of murder, but this was quashed and voluntary manslaughter was substituted. And there is an indication that the judgment is objective. The jury compared the defendant to how a reasonable person might behave, not what the defendant considers abnormal. So, of course, this tells us that this is an objective element. So we can also look to the case of Martin. Now, Martin was a farmer who shot a burglar as he was leaving the premises, so he's no longer a danger. Now, he was originally convicted of murder, but argued that he was suffering from diminished responsibility at the time. Now, there were several possible reasons for this abnormality of mental functioning. He had a personality disorder, he'd previously had a nervous breakdown, and also had suffered sexual abuse as a child. Now, his medical team also cited the mess that Martin's house was in, his habit of sleeping in his clothes and boots, and obsession with teddy bears as evidence of a disturbed mind. Of course, we've got abnormality of mental functioning here. And also the deep depression brought on by previous burglary 3 months earlier had substantially impaired his mental responsibility. So quite a number of reasons why this person might have argued that he had diminished responsibility. So in our discussion of the law, once we've covered the idea that the defendant suffered from an abnormality of mental functioning, we need to consider, was this abnormality of mental functioning caused by a recognised medical condition? And with respect to the recognised medical condition, this must be the cause of the abnormality, so it must arise from the recognised medical condition. Now, the condition itself doesn't need to be permanent, but at the time of the killing it must be present. Now, it can be induced either by disease or by injury, for example. Now, most medical conditions are defined in the International Classification of Diseases, which is prepared by the World Health Organization. So when we refer to recognised medical condition, we mean it's recognised by the World Health Organization. Now, we'll come to intoxication later on, but intoxication itself will not be a sufficient cause, although in recent years the courts have taken a more lenient view of alcohol dependency syndrome. We will come to this later on and explore this in more detail. Now, some obvious examples of accepted disorders from previous cases include things like anxiety disorders, personality disorders. This can include things like split personality disorder or multiple personality disorder, right up to paranoia and so on. Now, we've mentioned alcohol dependency, but we could also consider schizophrenia as a real example, which we're going to come to in a moment. But we could also have physical conditions which can affect the mental functioning, such as epilepsy, sleep disorders and diabetes. So all of these things can induce abnormality of mental functioning. So one famous example of a recognised medical condition could arguably be the case of Sutcliffe. So this was the Yorkshire Ripper, more commonly known, and of course claimed to be on a mission from God in murdering sex workers and other women. Now, he had schizophrenia, there was no doubt about this, there was medical evidence. Now, we're going to come to later why this person was not able to use the defence of diminished responsibility, but ultimately the jury found him guilty of murder. But he did have a recognised medical condition. So when we can use this case, we can use it to support that element. Other recognised medical conditions which have been allowed for diminished responsibility are the case of English, for example. So in English, a woman who killed could bring evidence to show her responsibility had been impaired through premenstrual tension, and diminished responsibility was available to this person. In Reynolds, postnatal depression was the basis for a diminished responsibility claim and was a recognised medical condition. And in Alevelaw, another famous case, battered woman syndrome in this case was considered to be a recognised medical condition. If you wish, you could also look to these cases. We have Price, Skirton, Hampson, Lawson, Bailey, Simcox, and all of these have a very similar outcome. The recognised medical condition in all of these is a variant of depression. You can obviously look to each of these cases and research them to find out why depression was caused and why it was considered depression in each case. Now, so far we've covered abnormality of mental functioning as a basis for a diminished responsibility claim, and the difference between that and the abnormality of the mind, because of course it can be a physical condition or illness as well. We've looked to the fact that this can be caused by a recognised medical condition. Now we also need to consider two things now with the third element. So this element needs to substantially impair the defendant's responsibility to do one of three things. So we're going to look at which one of those three things. Now a quick note is only one of those three things needs to be proven in any application of this defence. But of course we need to consider what the word substantial means. To what extent is the responsibility impaired by the abnormality of mental functioning? So the defendant must prove that the abnormality of mental functioning substantially impaired the responsibility, as we say, to do one of three things. Either the defendant does not understand the nature of his conduct, or the defendant isn't able to form a rational judgment, or the abnormality makes the defendant lack self-control or fails to exercise self-control. Now, of course, the people deciding this is the jury. The jury are able to make a decision as to whether one of these three things was substantially impaired. But of course, we need to consider what exactly does substantial mean. Now, in the case of Byrne, the Court of Appeals said the question of whether the impairment was substantial was one of degree, and it was up to the jury to decide. And this was from 1960. In Lloyd in 1967, it was held substantial doesn't mean total, nor does it mean trivial or minimal. It's something in between for the jury to decide, and again, it's a question of fact. Now, this is quite consistent with our approach to criminal law, particularly when we look at causation, for example. But as recently as 2016, the Supreme Court considered in the case of Golds what the meaning of substantial was. Now, it was pointed out there is no indication in the Coroners and Justice Act of 2009 that Parliament wished the word substantial to carry a different meaning from the interpretations of Byrne and Lloyd. So therefore, we agree that the common law is the right approach. So the nature here is what exactly is substantially impaired. If there is impairment, what exactly has the abnormality impaired the defendant's ability to do? So one of those first elements is the ability to understand the nature of his or her conduct. So this covers situations where the defendant is in an automatic state and doesn't know what he or she is doing. But it also covers situations where the defendant suffers from delusions and belief, for example, that he's killing the devil when in fact he or she is killing a person. And in this situation, he or she doesn't understand the nature of what they're doing. Now, it could also cover people with severe learning difficulties whose mental age is so low they do not understand the nature of what they're doing. It may be that the abnormality has substantially impaired the defendant's ability to form a rational judgment. Now, this is almost self-explanatory. We're not thinking clearly. So those suffering from paranoia, schizophrenia or battered woman syndrome might not be able to form a rational judgment. So even if they do know the nature of the conduct, they may not be able to form a rational judgment about his or her actions. And finally, we've seen particularly in Byrne, where the defendant was a sexual psychopath, the defendant might not have the ability to exercise self-control. Now, if there's medical evidence to suggest that this person is unable to control themselves, then perhaps this defence would be used. So it's only one of those three things we must use. Of course, there may be more in the scenario question, but my advice to you is to make sure that once you're applying, if you find one of these things, we're limited on time, aren't we? So we should make sure we focus just on one of those. And the final element to this defence is once we've established the defendant suffered from an abnormality of mental functioning, which was caused by a recognised medical condition and substantially impaired the defendant's responsibility to understand the nature of the conduct, or to not form a rational judgment, or to makes him lose control, we must look for the causal link. So did the abnormality provide an explanation for the defendant's acts or omissions? Now be careful here. We're not looking to whether the abnormality caused death. We've already proven murder before we apply this defence. So we're just going to explore this last element now. So what this means is the abnormality itself is the cause or significant contributing factor in causing the defendant to carry out his conduct which killed the victim. So what we're really asking is there a causal link between the abnormality of mental functioning or the medical condition and the killing? Now both factual and medical evidence can be taken into account here. So for your purposes, you will look into the scenario for factual evidence. Why did the person do what they did? But there might also be some suggestions in the article, in the scenario, which explain what medical evidence. So this person was recently depressed, or this person was suffering from schizophrenia. It wouldn't include that if there was no medical evidence of that. So be sure to use that as all your evidence. So another note here, the abnormality need not be the only reason provided it is a significant contributing factor. So again, this is quite consistent with our approach to law. And they are the basic elements of this defence. It may, however, be complicated where there is intoxication. Now, the starting point for this is, if you're drunk, then that's never going to be the basis of a defence for diminished responsibility, though of course it is its own defence. If you're drunk or intoxicated in some way and you suffer from an abnormality of mental functioning, then the question is, would the person have done the act without the intoxication? If they would, then perhaps we can still use the defence. And the final consideration is the intoxication due to an addiction? If so, then we may be able to use the defence, because that in itself forms the abnormality of mental functioning, and the alcoholism, or ASD, is the recognised medical condition. So the test from Stewart in 2009 is, was the defendant suffering from an abnormality of mental functioning? If so, ADS doesn't automatically amount to an abnormality. It can do, but we need to consider whether it will do, and the test comes from this case. If the answer is yes, then was the abnormality caused by the ADS? Again, if the answer is yes, was the defendant's ability to do anything subsection 1A of the Coroners and Justice Act 2009 substantially impaired on all evidence, including medical available? And of course, it's a jury to consider this. So we need to look for things like the extent and seriousness of the dependency. Of course, the more dependent and more serious this dependency is, the more likely it is that it's a recognised medical condition. We need to look also to the extent of the ability of the defendant to control drinking. The more voluntary that first drink is, the less likely it is ADS, and the less likely it is to be an abnormality of mental functioning or a recognised medical condition. And again, we need to consider things like, was the defendant capable of abstaining from alcohol? Was there a reason the defendant drank more than usual on this occasion? We need also to look at the defendant's pattern of drinking before the killing, and the defendant's ability to make decisions about ordinary day-to-day matters. Now, of course, you will not be able to glean information about each one of these points in the scenario question, but you need to be aware of them so you can consider them when applying the law. Now, of course, the more serious the ADS is, the more involuntary drinking is, the more likely it is that it will form part of a defence of diminished responsibility to murder. So, quick summary. Just being drunk will not in itself amount to an abnormality of the mind, but alcoholism might do. And it's up to jury to decide if the consumption was because of the alcohol dependency. And that's it. you're all up to date with diminished responsibility. You can look to the other videos to see other defences such as loss control and of course intoxication as its own defence.